Judge Stephanie Boyd gives a brutal warning to repeat offender Keenan Brown after sentencing him for robbery and aggravated assault with a deadly weapon. What starts as a routine plea hearing quickly turns into a powerful courtroom moment when Judge Boyd warns him that if he keeps going down this path, his next sentence could start at 25 years to life. This is one courtroom reality check you don't want to miss.
State.
Daniel Escobar for the state of Texas.
Defense.
Arlene Gay for the defendant.
All right. And are you Mr. Brown? Counsel, have you received all the discovery in each case and did you review it with your client?
Yes, all the cases we're pleading on except for one notation I was told today.
Judge, so on cause number 2022 CR 2790, there was a audio file that was mentioned in the prosecution guide from one of the witnesses. I had reached out to SAPD because we did not have that in our possession. SAPD reached out and said that they didn't have it. They updated me today, and that's when I told defense about it.
It's the conversation is noted.
Yes.
It's just the recording. If there was one ever made, it was not, and they told me, and that's one of the cases he's taken a plea on today.
All right. And knowing that, do you still wish to continue with the plea?
Yes, Your Honor.
And Mr. Brown, do you still wish to continue with the plea? I got it.
Yes, ma'am.
And are there any applications?
No, Your Honor.
And each cause number, I'm going to show you the court will find that the state is in compliance with discovering each cause number. And in each cause number, Mr. Brown, I'm going to show you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State and the cause number ending in 10495. Are you proceeding on the indictment as presented?
Your Honor, I believe there's a repeat offender enhancement. We are not proceeding on that. We are waiving that. But otherwise, we're proceeding as presented.
Okay. Any objection?
No objection.
And in the cause number ending in 2790, state, are you proceeding on the indictment as presented?
Your Honor, the state is going to waive the repeat offender enhancement, but otherwise proceeding on the case as presented.
Any objection?
No objection.
Mr. Brown, in each cause number, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, ma'am.
And the cause number ended in 2790, you're charged with the offense of aggravated assault with a deadly weapon. And the cause number ending in 10495, you're charged with the offense of robbery. Each of those offenses are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand? Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane in each of the cause numbers?
Yes, he is.
Mr. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Mm.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial in each of the cause numbers. And each of the cause numbers, I'm showing you the plea bargain page. Did you review those with your attorney? Did you understand it?
Yes, ma'am.
In each of the cause numbers, punishment is to be assessed at 5 years in the prison. There are no applications. The cause numbers will run concurrently. The state will take in consideration 2022 CR 2791, 2023 CR 5662. This is to run concurrent with your federal case 22 CR 246. And did you understand that if the court finds that there was a deadly weapon in the aggravated assault with a deadly weapon, then the court will enter an affirmative finding of deadly weapon. Did you understand that? Did you understand that to be your plea bargain agreements in each of the cause numbers? Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there hasn't.
Then in cause number 2022 CR 410495, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2022 CR 2790, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's pleas.
State offers State's Exhibit 1 in both cases. It's different States Exhibit 1s.
No objection.
All right. In each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we're just asking that the court follow the plea bargain, and I'd like to address the documentation of back time in this matter.
Okay. Then in cause number 2022 CR 10459, the court is finding you guilty. Court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 2790. Take in consideration 2022 CR 2791 and 2023 CR 5662. This will run concurrent with federal cause number 22 CR 246.
The courtroom falls silent as Keenan Brown stands before Judge Stephanie Boyd, facing two serious felony charges: aggravated assault with a deadly weapon and robbery. Both crimes carry massive consequences under Texas law, with possible prison time ranging from 2 to 20 years. But for Brown, this hearing isn't about proving innocence anymore. He has already agreed to a plea deal. The only thing left is sentencing, and Judge Boyd is making it clear she takes these charges seriously. Brown's attorney confirms that all discovery has been reviewed, though there was one missing audio recording mentioned by prosecutors. Even with that issue unresolved, Brown chooses to move forward with a plea agreement. Judge Boyd carefully walks him through every constitutional right he's giving up: the right to a jury trial, the right to confront witnesses, and the right to remain silent. Brown quietly answers, "Yes, ma'am," to every question. Then comes the critical moment. Judge Boyd explains the punishment agreement. 5 years in prison for each case, running concurrently, meaning both sentences will be served at the same time. She also warns Brown that because the aggravated assault involved a deadly weapon, there will be an affirmative deadly weapon finding attached to his record, something that could affect parole and future sentencing. Brown pleads no contest. The court reviews police reports and witness statements. After examining the evidence, Judge Boyd formally finds him guilty on both charges. His defense attorney requests credit for the time Brown already spent in custody, explaining he had been locked up since February 2022 because of overlapping federal custody issues. Judge Boyd agrees and grants him full credit for all time served. But the most powerful moment comes after the sentencing is complete. Judge Boyd looks directly at Brown and delivers a stern warning about the future waiting for him if he continues down this path. She tells him he needs to sit in prison and truly think about how he got here. Then she drops the line that changes the tone of the entire hearing. "At some point, you're going to be labeled as a habitual offender." She explains that under Texas law, habitual offenders can face minimum sentences starting at 25 years. Not probation. Not 5 years. 25 years minimum. The courtroom grows heavier as Judge Boyd urges him to change his life before it's too late. She tells him to work on his anger issues and rethink the direction he's heading before the justice system permanently defines his future. For viewers watching, this hearing becomes more than just another sentencing. It's a harsh lesson about how repeated violent crimes can slowly destroy a person's freedom, future, and identity. And once Judge Stephanie Boyd finishes speaking, the message is impossible to ignore. Next time, the consequences could be far worse.
5, the federal case 22 CR 246. Take in consideration 2022 CR 2791, 2023 CR 5662. Is there anything else with regards to sentencing in that case?
No, Your Honor.
And in that cause number as well, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
34.
All right, you're 34. And it appears that you determined to spend a lot of time in custody. After this time, you need to sit at the jail, sit at the prison, and think about, why am I here? How did I get here? Do I really want to live my life? Institutionalized. Because if you do, what's going to end up happening is at some point, you're going to be labeled as a habitual offender. And in Texas, when you're a habitual offender, depending on the offense, your minimum starts at 25 years. Do you understand?
Yes, ma'am.
So you're going to have to change your ways. And if you have an anger issue, you need to work on it. All right. Good luck to you. You're welcome. Can I see the other files on here so I can write in the file?